Ma'am. Oh, she's not connected.
Hello?
Ma'am,
Can you hear?
drive on Zoom.
Hello?
Pull over.
Can you hear me? I'm sorry.
I'm not muted, am I? No. Can you hear me?
I can hear you. Can you hear me, ma'am?
Yes, I can hear you, and I am telling you to pull over.
Yes, ma'am. That's what I'm attempting to do. Thank you. Give me one moment. I had to pull off the freeway. Oh, okay. I'm going to go around this corner right here.
I fought her.
Okay, I'm sorry about that. Okay. Can you still hear me?
I can still hear you.
Okay.
Couple rules of court Zoom etiquette for you. Okay. Do not drive on Zoom. You can get in a car accident. That would be a bad thing. Okay.
Yes.
Also, please put your cigarette out.
Oh, I didn't even realize I still had it. I'm so sorry.
It's okay. I realize that this is over Zoom and things are strange, but you are still in court. Okay.
Thank you, ma'am.
And
I'm
you
sorry
are
about that.
definitely not supposed to be driving while you're on Zoom. Okay. That settled. Your name is Sheila James, correct?
Ma'am. Yes, ma'am.
Okay. Now calling case number 23W003419. I'm seeing, it's the date and time set for a show cause hearing. I'm seeing a balance of $150.
Yes, ma'am.
Okay. Okay. When do you think you can have that paid off?
If you're willing to work with me, I can have it paid in full by January 26th.
Okay. Then what I will do is set you for another show cause hearing on February 20th.
Okay.
Okay. It'll be over Zoom like this at 9 a.m.
Okay.
Okay. February 20th.
Okay.
And when you call in next time, you will be stationary.
Yes.
And you will not be smoking. Thank
I'm
you.
so sorry about that. I didn't even realize I still had it.
No, that's it. It's fine. Just, you're still coming to court, even if it's online. Okay.
Yes, ma'am.
Okay. So you said you're going to have it paid off in full by the next time we come to court. So that's February 20th. If it is paid off in full by then you don't have to come back. Okay.
Okay.
If it's not paid in full, then we'll at least have that date so that we can check in and see what's going on.
Wonderful.
Okay. Do you have your next date? Did you write it down?
I do have it, but I will write it down.
Okay.
And that's at 9 a.m., ma'am?
Yes.
Okay. All right, yes, I'll have it paid in full by then, but
Okay.
yeah.
Okay. Then if we see you again in February, great. If you've got it paid off, even better. Okay. You are free to go. And
thank you.
Please remember not to use your phone while you're driving.
Thank you, ma'am. You have a wonderful day.
You too.
Have a Merry Christmas.
You too. Thank you.
Bye-bye.
State your name.
Tamika White.
White, are you there?
Yes, Tamika White.
Thank you. We're here for a pretrial today, Mr. Burkett. What would you like to do?
Yeah, I'm sorry, I couldn't hear you.
We're here for a pretrial today, sir. What would you like to do?
Yes, it is, Your Honor. Okay, I'd like the prosecutor to put her offer on the record, please.
Sure. Ms. White, as well as the other co-defendant in this related case, have an offer to plead as charged with a prosecutor's deferred and a sentence agreement to 18 months probation. The prosecutor's deferred agreement is one that, when probation is successfully completed, the charge can be dismissed from one's record.
Okay, I thought you had agreed to reduce it to 12 months on Ms. White.
Well, they both have the same
Probation
offer.
for 12 months. And then if she completed a certain part of it. I'm sorry, I couldn't hear you. You're breaking up again.
Actually, Mr. Burkett, it's you that's breaking up. Your connection is terrible.
Okay.
Mr. Burkett, I can try to clarify that. They both have
I'm
the
working
same.
on that right now, Your Honor.
Mr. Burkett, we can't even make out what you're saying.
I'm not at my office.
That doesn't change anything.
Beg your pardon?
That did not change anything, sir. We still can't make out what you're saying.
What did you say?
All right, this is not gonna work.
What's- Okay, Your Honor, I signed up on a new computer. I'm hoping that it works. Can you hear me now? Okay.
Yes, we can hear you much better, Mr. Burkett.
I apologize again, Your Honor. I'm somewhat handicapped and trying to work from home.
All right.
Okay, now, I was under the impression that it was 12 months, but Ms. White, you heard what the prosecutor is offering you.
Mr.
It's up
Burkett,
to
let
you.
me clarify first. Mr. Burkett, let me clarify.
Yes,
It's 18 months probation. However, the statute still applies with respect to early discharge. So if she is successful, it also would be a potential for 9 months as well.
What
Okay.
she's saying is that if she qualifies at that time, she could petition to be discharged at the 9-month mark.
okay, I understand that. Position is Ms. White, do you understand that?
Yes, I understand.
Okay. Do you have any questions?
Not at the moment.
Go ahead.
Not at the moment. So,
Mr. Burkett, did you need a breakout room with your client? Because we don't do all this on the record, sir.
Okay.
Is that a yes, you do?
Please.
All right, we'll put you in a breakout room. Do you want the other client in at the same time?
No.
For the people.
Once again, Your Honor, Raymond Burkett on behalf of Ms. White.
Thank you. Where are we with Mr. Burkett, please?
Ms. White, will you identify yourself again?
Tamika White.
Ms. White, may I proceed, Your Honor?
Yes, I asked you where were we with this case a while ago, sir.
Your Honor, Ms. White is prepared to accept the offer that the prosecutor has offered to her. Is that correct, Ms. White?
Yes,
And you understand it?
yes.
And I've gone over, go ahead.
I understand that it could be reduced to 9 months and it won't be on my record and my gun rights will be restored.
I make no representations regarding your gun rights. And I don't know if the prosecutor is either. I think that's up to the board.
That's not something we control.
Do you understand that part, ma'am?
Yes.
All right, is this what you want to do?
Yes,
All right, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
yes,
Thank you. It is my understanding, ma'am, that you're going to be pleading guilty as charged to an account of assault, or assault and battery, which is a misdemeanor carrying a maximum of 93 days and or up to $500 fine plus court costs. In exchange for that plea, the prosecutors agreed to offer you the prosecutor's deferred and 18 months of probation. Under the prosecutor's deferred, if you do everything you're supposed to do on probation, then this matter would not be on your record. Do you understand that part?
yes,
All right. I'm going to go over some rights that you have that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay?
okay,
You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself, or you could choose to remain silent. If you did choose to remain silent, the prosecutor could not comment on that. In addition, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand all those rights?
yes,
You understand you're going to be giving up all those rights and you're not going to be having a trial of any sort?
yes,
You also understand that there's no automatic right to appeal this decision. So the decision that you're making today, in all likelihood, is going to stick with you, Miss White. Do you understand that?
yes,
And do you also understand, ma'am, that if you were on probation, parole, or bond, which if you're getting a prosecutor's deferred, it's not likely you were, but if you were on probation, parole, or bond on December 16th, 2022, then this particular offense could be a violation of either one or all of those.
yes,
Were you on any of those?
no,
All right. And are you a U.S. citizen, ma'am? If you're not, then you could have immigration consequences.
I am a US citizen.
All right, thank you. We're now gonna turn to the offense itself. So the charge of assault and battery, how do you plead?
Guilty.
Has anyone promised you anything other than what we placed on the record to get you to plead guilty here today, ma'am?
No,
Anyone threatening you in any way, shape, or form?
no,
All right. So on December the 16th of 2022, were you at the vicinity of 3011 East Michigan Ave here in Ypsilanti Township, ma'am?
yes,
And at that time, did you assault and or batter a Miss Rosanna Kelly?
yes.
What did you do to her?
We fought. We had a fight.
All right, that is not a sufficient basis for a plea.
We fought. I fought her. I fought her.
Yeah, but that entails a self-defense potentially, and that's not a sufficient basis for a plea.
I don't have anything else to say. That's what happened.
I understand, ma'am. I'm not actually talking to you anymore. I'm talking to your attorney.
Oh, okay, I'm sorry.
Your Honor, may I ask a few questions?
You may.
Ms. White, did you strike or did you attempt to strike this lady? Offer to hit her?
I did strike her. I can't say who struck first, but I did strike her.
Okay, and were you all engaged in an altercation?
Yes,
Okay, and during this altercation, you did hit her.
yes,
Is that correct?
yes.
Yeah, I don't have anything.
That's still not a sufficient plea, Ms. McDuffie.
Miss White, on that day and time, at that location, did you confront, and by confront, at this point, I'm just saying, did you approach Miss Kelly in the parking lot?
Yes,
And did you get into an argument
yes,
about social media?
yes,
And are you, then I guess, when you recall striking Miss Kelly, how did that happen?
I know we were face to face, and then I don't recall who hit who first.
So Miss White, are you saying that you recall being hit by Miss Kelly?
Yes, she hit me.
And you believe that that was before or after you hit her?
I don't recall.
Okay, we don't have a plea.
Okay. Your Honor, I guess under these circumstances, we don't have a play as to Ms. White. And I guess we'll have to sit this down for a jury trial for Ms. White.
Thank you. Final settlement conference in this case will be on January 25th, 2024 at 11 a.m.
1 second, January the 25th at what time, Your Honor?
11 o'clock a.m. is the final settlement conference.
Your Honor, it can be done by Zoom.
Yes, it can.
Thank you, Your Honor. Thank you very much, Your Honor.
Well, let me give you your next date, which is going to be the jury selection, which is in person. Jury selection is February 2nd, 2024 at 8:30 a.m. Bond is continued. We'll see you all then.
Thank you, Judge.
Well, I guess you're going to be here for your next case. Ms. White, you're off that.
Sitting in the front row a moment ago.
Yeah. Yolanda Martin?
Yes, sir.
Judge, you got two drug patch results.
Have you seen it? Did we? Do you need
He's seen
copies
it.
of this?
He's got it. Ellie emailed him a copy last week.
It's been showing since you've been on bond, man, in cost number 23-41301. And by the way, Mr. West is here, your attorney. You have tested positive for cocaine, which is a violation of your bond condition. On it was a sample was taken from you on October 12th, and another one was about 2 weeks later on October 25th. Those have been returned positive for cocaine, which is a violation of your bond conditions. What's your bond now? Okay. Well, Mr. West, what do you have to say? Anything?
I have spoken with my client about this. She is adamant that she has not been using cocaine. And it's been her drug of the past because she's tested positive and her bond was revoked. You put her back in jail and she did how long you been in jail? Yeah, and then she was
Sorry, it's the tests are what it's in your system. It won't get into your system unless you absorb it in some way, whether you're taking it directly or you are around people and you are getting the cocaine absorbed into your system, which is still your responsibility. The court stands by these tests. If I didn't stand by this test, we wouldn't need the tests. They have a validity and they have a worth, and it will your answer is just denial. The court stands by the findings. Our bond is 20.
Your Honor, I would request that if there's any way we could do the drug test today, an instant.
That doesn't purge history.
Well, I know in the past we've had issues with the drug. I mean, I've had cases where drug patches were.
I'm standing by the test. Sorry. We're either gonna have drug patch or not. And if people are gonna say they're not worthy, then we're wasting a lot of money on something that is a proven standard and is accepted. So that's what we're gonna, sorry, your bond is revoked. It is.